Okay, welcome back. This is the last video that I'm going to make for this week, and it is, I guess it'll be the longest one. And really what I'm going to be doing is walking through a number of the cases. All of these are referred to in the readings, and I just really want to use them as examples so that we can get a better sense of the ways in which sanctions will be applied when there is a finding of unprofessional conduct or so unsatisfactory professional conduct or professional misconduct. And so by looking at the cases, you'll get a sense of where that grey line turns to black, number one, but also it'll give you a sense of basically how to navigate the not insubstantial reading. All of these cases are dealt with in Del Pont or in Parker and Evans. And there are many other examples as well. I've just picked out the ones that I think are going to help us the most. And I'm kind of following these kind of just general themes here. Okay, so some of the cases really go to a question of competence, like are you, excuse me, are you conducting your practice in a way that demonstrates competence and at standards that are appropriate for the profession? There are a number of cases that deal with issues now that relate to the mental health of a practitioner, and so whether the circumstances have been exacerbated by a mental health issue or whether the mental health of the practitioner impacts that practitioner's capacity to be a fit and proper person. Now, the attitudes of the world, but the profession have changed substantially in this regard. And this is something that you are really going to need to think about because, well, let's talk about the because when I get there at more detail. But there are definitely changing attitudes in relation to mental health. And the short, too long didn't read answer is that you can be a fit and proper person and still suffer from a serious medical condition, including a serious mental health condition, provided that you are taking all of the steps that you need to ensure that that condition doesn't affect your integrity, doesn't affect your ability to be a competent lawyer. Now, many of the cases also they relate to money. And I've said a number of times that many complaints arise as a consequence of clients' dissatisfaction with the way that they've been billed or charging, etc. Often it takes getting the bill to really prompt action. So it's often matters that look like they're matters about costs, which are really matters about delays or lack of communication with the client. And so we'll look at a couple of those cases so you can get a sense of what they mean. Another common issue that arises is questions or allegations of unsatisfactory professional conduct or professional misconduct relating or arising out of a lack of supervision of other people in a law practice or a lack of vigilance in monitoring the behaviours of staff or of partners. And of course, we'll also talk about what happens when a lawyer commits a crime and when will the commission of a crime be professional misconduct and when will it not. So let's crack on a case at a time. The first one is Legal Services Commission and Treby 2009 decision. Now, in that case, ultimately, it was the client's refusal first to explain a bill to the client and then to refusing to provide the Legal Services Commissioner with a proper explanation as well. That led to a finding of unsatisfactory professional conduct. Single related incident, ultimately unsatisfactory professional conduct. On the other hand, in this particular case, so Pippa Sampson was a lawyer out in Glen Waverley, and what she did is, like, as a vigilant lawyer, is she acted for a company that, from memory, it was a video store franchise, and so she was trying to collect unpaid rental fines. So acting in their debt collection practice, and she basically mocked up letters of demand so they looked like they were court orders, that they were basically, unless you pay this money, you will get arrested. So ultimately it was found that these forms were calculated to mislead and to intimidate and grossly exceed the legitimate assertion of the rights or the entitlement of the client, including claiming that the debtor, in the absence of a contractual entitlement, had an obligation to pay the costs associated with the preparation of the notice. And so she was found to be in breach of Rule 28.1 of what was then the 2005 rules. So in other words, she'd made a false representation. And this was found to be professional misconduct. In a separate penalty hearing, it was the sanctions that were implied was she was required to obtain 2 additional points of professional development in the area of ethics and professional responsibility in each of the CPD years ending March 2014 and 15, and then she had to pay half of the Legal Services Commissioner's costs. But again, the damage in relation to her practice was more ultimately reputational than anything else, but it was still professional misconduct. Another thing that will be considered is whether there is a pattern of misconduct, so a repeated misconduct. So a solicitor here purported to act for a client and commenced legal proceedings on the client's behalf without actually getting instructions. So this is a car damage case in which the solicitor acted on instructions of a recovery company without actually checking with the driver owner of the car. But there was a pattern of offences here, not just a one-off, and they spanned a period that began in 1985 and continued through till 2008. And so in that particular case, the court found that having regard to the need to protect the public, so recognise that language, protect the public, and having regard to Mr. Brott's pattern of conduct over an extended period, the tribunal considers it appropriate to refer Mr. Brott to the Supreme Court. And the Supreme Court confirmed that conduct, and Mr. Brott was struck off and prohibited from reapplying for 8 years. So essentially putting an end to his less than brilliant career. So in LSC, Legal Services Commissioner and Turner, this case involved a barrister who failed to lodge income tax returns and GST BAS statements, and ultimately became insolvent under administration. VCAT ordered a reprimand and a fine, $5,000, but allowed Mr. Turner to continue to hold a practicing certificate, but subject to the condition that he inform the Commissioner in writing of any failure to comply with taxation obligations within 7 days of the failure occurring. Mitigating factors included his psychological state. So he didn't have a mental illness, but there was evidence given that he was incapable of taking action, that he just was overwhelmed by all of the things that he had to do. The fact that he had commenced rectifying the tax issues, that he'd expressed remorse throughout. There was a delay in prosecution, which caused additional stress, and he was at the age of barrister. I was going to say he was old, but he was not much older than I am. He was 60. And so he was seeking rehabilitation, his personal situation, because he was otherwise unemployable. So the court said, and the language is on the slide if you want to squint, having regard to all of the above factors and weighing them in the balance, the tribunal is satisfied that suspension of the respondent's practising certificate is not warranted. The major mitigating factors leading to this conclusion are the acceptance of the impact of the respondent's psychological state and the effect of the inordinate delay on the conduct of this matter. So the Legal Services Commissioner asked the Supreme Court to overturn VCAT's decision as manifestly inadequate and to suspend Turner, but the Supreme Court ultimately said no. They remitted it back to VCAT, and VCAT reaffirmed its earlier decision. So what do we learn from this? A broad range of factors are going to be taken into account, and the attitude and the remorse of the practitioner concerned will be key to those. So one of the most serious forms of professional misconduct is any fraudulent misappropriation of client funds. And so any purposeful or dishonest use of client money that has been entrusted, that language is not accidental, has been entrusted to the solicitor. Trust account irregularities are, when they amount to professional misconduct, they will usually result in a striking off or a cancellation of the legal practitioner's practicing certificate. It's interesting that trust account irregularities are the only kind of breaches that the law requires be reported by other lawyers. If you have an issue with your trust account and you do not report it, that itself is an offence. I think the words here from Chief Justice King from the South Australian Supreme Court back in 1982 are really instructive here. That the court has a duty to vindicate the inviolability, so the completeness and absoluteness, the without damage, or the, sorry, I'm stretching for words here. I want a synonym for inviolability. So, which is really about how strong that level of trust needs to be, and how strong the duty is that a practitioner has to treat their client's money in all respect as the client's money, and to use the client's money for the client's purposes and for no other purposes. Whenever a client's money is deliberately used for a purpose other than the purpose for which the client entrusted it to the practitioner, there is an act of dishonesty. So technical breaches of trust account requirements involving no dishonesty can still amount to unsatisfactory professional conduct. But a technical breach involving no dishonesty is quite different from any considered or technical or actual use of client funds, any use of the trust account, even if the client never loses anything. It doesn't matter. This is one of the most serious breaches of trust that a practitioner can be involved in, and will usually see the harshest of penalties. Charging excessive costs can be misconduct, both at common law and under the uniform law. To have a look at Section 298D. The question is usually whether the practitioner has charged fees which are grossly in excess of those that would be charged by lawyers of good repute and competency. And that goes back to Melvey. That's Melvey, a 1996 case from New South Wales. Principles relating to overcharging that have been developed by the former Solicitors Board include things like it's insufficient that the fees are merely excessive. Charging grossly excessive fees may be misconduct even where the client is satisfied with the charges. So have a look at what Del Pont has to say in this regard. At the end of the day, we're looking at when it's gross overcharging, we're likely to see professional misconduct, that simply charging high fees is unlikely to be unsatisfactory professional conduct unless there is some significant reason, some repetition or some other issue that comes out. So in order to determine whether overcharging is gross overcharging or not, there are a series of questions that the court will ask. How much costs would have been assessed if they'd been assessed using a cost order? Novelty, complexity, or difficulty of the case or the transaction can be taken into account. The experience and of the lawyer involved, the more specific and particular a lawyer's experience might be, and the more relevant it is, the easier it is to justify a higher charge. The quality of the work that is done, the amount of time that's spent on the matter, the responsibilities of those involved, so what liability does the legal practice take on, and ultimately what the case is worth. There's a couple of examples here. The New South Wales Legal Services Commissioner and Keddy is a case back from June 2012 where a solicitor admitted to gross overcharging of a paraplegic client. So the court took into account the vulnerability of a particular client. Also, there's the case of Jan Horrock, a Melbourne suburban lawyer who was banned for 6 years back in 2014 for grossly overcharging. So at that time, a charge of $395 an hour to read texts and check accounts online was seen as gross overcharging. Now, not quite 10 years later, and I'm not sure that that result would be the same. We've also seen this case before the Law Society and Foreman. We talked about it when we were talking about fit and proper person some weeks ago. And it's worth remembering that Ms. Foreman, she forged timesheets and other documents, and ultimately it was found, her conduct was found to be professional misconduct. She was hit with a $20,000 fine and was struck off. What was really important there was probably less the overcharging, more the deliberate falsification of the documents and the other dishonesty. And when there is dishonesty, we are looking at failure to be a fit and proper person, which is more likely to be found to be professional misconduct and leading to a striking off order. So in this case, Legal Services Commissioner and Chadwick, in this case we had a solicitor who suffered an extreme mental illness and suffered significant adverse effects in terms of his family, work and life generally. So sometime around 2006, he relinquished his partnership for no financial compensation under the effects of the illness that he was suffering. And he received treatment for his mental illness, which by mid to late 2007 appeared to be having a positive effect. So with the help of some friends, he then set up what was intended to be a sole practice, but his health wasn't as good as he thought it was, and he relied unduly and inappropriately on others to set up the practice, and then provided inadequate supervision to his clerk and his bookkeeper. Now, it turned out, just to add insult to injury, his bookkeeper was a bit of a crook, he didn't realise it, but his bookkeeper, Miss Kelly, actually incorporated a company and operated a bank account that was styled like a solicitor's trust account in the name of the company. And at no relevant time was Mr. Chadwick actually a director or a shareholder of the company. The account was not a trust account for the purposes of the Act. And so essentially, the claim that was made against him was that he had failed to properly supervise the clerk and that monies that should have been paid to the trust were paid into what was effectively an office account. And Mr. Chadwick when he found out about this, he reported it. He also gave some undertakings. He agreed that the Legal Services Commissioner could seek and obtain information from his treating doctor about his attendance at appointments and his taking of medication and his compliance with a prescribed treatment regime. Once a year, he agreed that the Legal Services Commission can get a general health report about him. And he agreed that he wouldn't make any application for a practicing certificate that would authorise him to receive trust money for at least another 12 months. Now, why this kind of complex result, quite intrusive result for the lawyer? The primary consideration that was given was the protection of the public. As a main cause of misconduct here was extreme mental illness, and he was managing that mental illness. The undertakings were considered acceptable, together with a ban on him having no trust receipts for a 12-month period. Generally, Del Pont says that pleading mental illness or stress generally won't overcome dishonesty if no attempt is made to particularly if no attempt is made to manage the condition. But it will be taken into account where there is remorse, and particularly where there is no dishonesty, and where there is evidence that a treatment plan is in place. Now, next trust account one that I want you to think about is Legal Services Commissioner in Telhouse, another 2013 case, an older one, of course, but I think it's really instructive. So Mr. Telhouse failed to pass on around $35,000, which he received on trust for a client, and instead spent that money for his own purposes. He basically repaid about half of the money back about 5 years later. He failed to provide a bill or any explanation for taking the fees when he for about $18,000 of the fees. He failed to take action to protect his client's interests, in that he didn't provide any further information that they requested by the trustee in bankruptcy of the estate, against which Mr. Telhouse had lodged a claim on Mr. Stewart's behalf. He also failed to deposit about $1,500 on behalf of that same client into trust, creating a deficiency in his trust account. He didn't pass that money on to his client at any stage. Look, there's a list of different things that he did. He failed to lodge GST returns relating to a number of tax quarters over about a 3-year period. He made a false declaration in an application for a renewal of his practicing certificate. He made another false declaration in a subsequent application for renewal of his practicing certificate, basically relating to offences he'd been found guilty of, saying that he hadn't been found guilty of them. And then a third time, he made another false declaration, again saying that he had lodged income tax returns that he hadn't lodged. He failed to respond to statutory demands that he provide information. I mean, we're looking at a huge number of different offences here. And ultimately, his conduct demonstrated a lack of fitness to practice. And he was referred to the Supreme Court for striking off, plus an order to pay in the order of $11,000 in costs. Now, this is my emphasis here, but senior member Jonathan Smithers in the judgment said the following: in my view, Mr. Telhouse's conduct, especially his misappropriation of client funds, associated breaches of trust accounting requirements, and false statutory declarations, comprises a clear basis on which a recommendation should be made to the Supreme Court that his name be removed from the roll of practitioners. His conduct demonstrates that he is not a fit and proper person to be entrusted with the responsibilities of being a legal practitioner, and is likely to remain so for the indefinite future. In this regard, I note that he has, since 2008, to reflect on his conduct, but has given no indication that any steps have been taken towards rehabilitation. Indeed, he has chosen not to engage with the Legal Services Commission investigation or VCAT hearing processes at all. In my view, striking off is called for the sake of the protection of the legal profession as a group, the courts and the justice system community, justice system and community confidence in that system. So, repeated action, lack of remorse, lack of any action to take any steps to rectify the situation or to participate in the investigation, and repeated dishonesty all lead to the most serious of sanctions altogether. I mentioned this earlier, that another example of failure to supervise or be vigilant, this is a Foreman case. Different Foreman from the one that we've referred to before, not the family lawyer Foreman, another Foreman. This Foreman was a sole practitioner who failed to supervise the work of an experienced managing clerk who ran the firm's mortgage practice. Client money was lent on inadequate security. Ultimately, the Court of Appeal said that the extent of a practitioner's responsibility to supervise depends on the competence and integrity of the employee and the nature of the transaction. The duty to supervise extends to at least having sufficient knowledge of the transactions handled by employees in order to be satisfied that transactions are handled competently and efficiently, trust accounting requirements are observed, ethical obligations such as those relating to conflict of interests are properly observed. So a practitioner doesn't need to scrutinise every step of the transaction handled by an employee. The practitioner may be in a position to a practitioner may be in a position, from past knowledge and experience of the employee, to exercise a more general supervision. But the practitioner must consider the extent of the supervision necessary in each case and maintain a sufficiently close oversight to ensure that the matters referred to are observed. And so if a practitioner is aware of factors which indicate greater scrutiny is required. So in the particular case of Foreman, even though it was he was a very experienced clerk, he was also an undischarged bankrupt. So there was a clue that the practitioner ought to be paying closer attention. If practitioners don't observe the full extent of the obligations and impropriety is grave, then there can be professional misconduct in the absence of dishonesty. So in other words, even if the practitioner themselves is not dishonest, but their lack of supervision is such that they are not meeting the fit as opposed to the proper part of fit and proper, then there still can be professional misconduct. Foreman ultimately deceived the client and other practitioners and the court, and only confessed when he was confronted with evidence. This also went a long way to the ultimate finding, and Mr. Foreman was struck off. Supervising or being vigilant doesn't just extend to employees, but also to the activities of one's partners. So in Mayers, Mayers was a member of a partnership that had practices at 2 locations. Basically, he ran the city office, and his partner, Mr. Cole, ran a suburban office and conducted all the accounting in the practice. Mays completed the distribution of a deceased estate without checking the trust account ledger records of the estate funds. And shortly after this, he was relieving Cole at the other office when, checking the ledger, he saw that $65,000 had been transferred from the estate account to another account. So he asked Cole about it and accepted his explanation that he transferred the money in error and was going to adjust the card immediately by transferring the money back. And then he made no further inquiry. But a few months later, Cole told Mays that he'd been misappropriating client funds. So that $65,000 was only one example. There was a total of $180,000 over a 4-year period. Mays had played absolutely no part in it, disclosed the issue to the Law Society pretty much immediately, and disciplinary action was taken against him, alleging he had willfully breached the relevant statutory provisions. The Court of Appeal ultimately found that Mr. Mays had been put on notice that things were happening that called for him to check the trust account ledgers. If he'd looked at the account to which the $65,000 had been transferred, he would have seen that irregularity, which, if he'd followed through, would have resulted in him knowing that his partner was a cheat. So partners have a joint responsibility to comply with the rules relating to trust money, and the extent to which each partner should concern themselves with the financial controls of the firm is going to vary with the size of the firm. Each partner has a responsibility to see that proper systems are in place, including in a incorporated legal practice, appropriate management systems, and to check that the systems are operating properly. The hard bit here is that the mere existence of a system doesn't relieve the partners from personal vigilance. Willful misconduct can occur if a person acts with reckless carelessness. In other words, if they don't care what the results of that negligence might be. By this test, Mr. May's failure to check the trust account record was seen as being willful, and he was found guilty of professional misconduct at common law. The court rejected earlier dicta in a case called Myers and Ellman that negligent cannot constitute professional misconduct. So again, it goes to this idea of fit and proper person. And if you are negligent, you may not have acted improperly, but you may not be fit to be a legal practitioner. So, what happens if you commit a crime? So let's start with Crowley, which is a case relating to the former solicitor of this gentleman here, Mr. Alan Bond, who was once one of Australia's richest men. He ultimately went to jail for a range of reasons, and maybe if he'd had a lawyer who had higher ethics, he might have been dissuaded from some of the activities, who knows. Mr. Crowley was a legal officer. He worked Crowley was not Mr. Bond's lawyer. He worked for the Commonwealth Corporate Prosecutions Branch of the Commonwealth DPP. And basically, when Mr. Bond was being prosecuted, Crowley was directly involved in preparing the submission to the Attorney General to get the prosecution underway. Mr. Crowley then contacted Mr. Bond's son and offered to provide some of the confidential documents that comprised the submission to the Attorney General in return for the payment of $2 million to an offshore account nominated by Mr. Crowley. Now, John Bond didn't accept that offer, but Crowley, not to be dissuaded, deposited some of the documents alongside Bond's letterbox. John Bond, so Mr. Alan Bond's son, passed those documents on to his father's solicitor, who turned them over to the federal police. Now, I now owe that solicitor an apology because I was just casting aspersions a minute ago when I misremembered the case. So clearly, Mr. Bond's lawyer was an ethical lawyer. He did the right thing, but Mr. Bond clearly did not in the longer term. So anyway, let's go back to Mr. Crowley. He was charged, convicted and sentenced to a term of 5 years imprisonment, essentially for bribery. And a motion was brought by the Legal Practitioners Disciplinary Tribunal in the Supreme Court that he be struck off the roll of practitioners in WA. And essentially what they found was an offence that was committed in a professional capacity is professional misconduct. The full court, Supreme Court of Western Australia, said that the purpose of the jurisdiction to strike off is to maintain a proper standard, not to punish. The question is whether by reason of the conduct by which the solicitor or the legal practitioner has been found guilty, the practitioner is a fit and proper person to continue practice. And the gravity of the offences made it obvious that Crowley was not a fit and proper person to remain a member of the legal profession. Okay, so what happens if somebody commits a crime that is unrelated to their legal practice? So Rees Sawley is a very old case from New South Wales and is authority for the proposition that even if unlawful conduct cannot be proved beyond reasonable doubt, it may still constitute misconduct if its occurrence can be established on the basis of probabilities. So in other words, Briginshaw. So the Briginshaw test, where the High Court held that where a civil case involves allegations of criminal conduct, fraud, or moral wrongdoing, which may lead to grave consequences, then the judicial approach should be a closer scrutiny of the evidence. So if an offence is unrelated to practice, the question is ultimately whether it relates to professional misconduct will depend on the nature, character, and frequency of the offending behaviour. Some offences of themselves indicate unfitness because a conviction undermines the integrity of the profession. So any serious offence involving dishonesty or violence where there's premeditation. So if unlawful conduct cannot be proved beyond reasonable doubt, it can still be misconduct if its occurrence can be established on the balance of probabilities. And so that's our Briginshaw test in action. So let's think about the kinds of actions. So Ziems, it's a 1957 case, but basically involved a barrister who killed a motorcyclist while driving under the influence of alcohol. He was found guilty of involuntary manslaughter and he served 2 years in prison. The Supreme Court struck him off on the basis that it was incongruous for a person serving a sentence for a serious crime to remain a barrister. The court declined to consider the circumstances of the offence, so Mr. Ziems appealed to the High Court. Now, the High Court, 3-2, allowed the appeal and instead suspended him during the term of his imprisonment. 3 members of the court held that it was appropriate to look at the circumstances of the offence, and the evidence didn't justify a finding that he was unfit to practice at the bar. Justice Kiddo said that there were many kinds of convictions that don't make a person unfit to practice. Manslaughter is a serious offence, clearly. But the reason for regarding it was not a reason which went to his fitness to practice. It wasn't a premeditated crime. It didn't indicate any tendency to be violent or any lack of probity. It was an isolated incident which didn't warrant any conclusion about Mr. Ziems' general behaviour or his inherent qualities. I told you this is a long one, I'm going to talk too much. And Justice Fulliger observed that misconduct in the course of professional activity will generally have a much more bearing on the question of fitness to practice than personal misconduct. LSC and PFM is a case about a lawyer who falsified an academic transcript in order to get a job, and who ultimately pleaded guilty to 6 charges of professional misconduct at VCAT. So VCAT gave him this pseudonym, PFM, due to considerations for his mental health. And the issue was, so PFM actually came to the attention of the Legal Services Commissioner through a complaint that was made by the former employer. So following a really lengthy investigation, the Commissioner brought 6 charges of professional misconduct against PFM relating to supplying recruitment agencies with forged academic transcripts, providing false information on a CV, making false representations about his employment status, and making false statutory declarations to the LIV, Law Institute of Victoria. So during the tribunal hearings, Senior Member Smithers from VCAT noted that PFM had provided false and misleading information to the investigators, causing the investigation to be significantly drawn out. He also described the conduct about which PFM was charged as comprising a systematic dishonesty rather than a momentary or an abhorrent lapse. In his defence, PFM presented psychiatric reports as evidence that showed that he was suffering from a major depressive disorder, and this has affected him and caused his wrongdoing or affected his wrongdoing. When assessing the evidence, the senior member Smithers found that there was no real causal link between PFM's mental illness and his lack of candour to VCAT. Further, he found that PFM was not a fit and proper person, and that it is likely that he is unfit to practice permanently, or at least for the indefinite future, because he is not a person of honesty. So VCAT found in order for a penalty to be mitigated due to mental illness, there needs to be a cogent and compelling evidence that of the requisite relationship between the mental condition and the offending conduct. Here the evidence fell short of that. On the evidence presented, the tribunal found that PFM's mental health status didn't have any effect that was relevant to determining what the penalty is. Of 5 of the charges, and only marginally at best the 6, really related to dishonesty, not to his mental condition. So the tribunal made an order that he not be employed by or consult for a law firm without the approval of the Legal Services Board, that he may not be granted a practicing certificate before, I think it was an 8-year period, and he was ordered to pay the Commissioner's costs at $25,000. So VCAT decision, you can find it on the OSLE website, and it's quite useful. VCAT also referred PFM to the Supreme Court for his name to be struck from the roll of practitioners. And Justice Elliott ordered that his name be removed. In giving his reasons, Justice Elliott said it is abundantly clear that by reason of the nature and severity of the charges proved, the length of time over which the offending conduct occurred, and the lack of genuine remorse, at least for an extended period of time, and the current mental state of PFM, it is appropriate that his name be removed from the roll of practitioners. So the issue of PFM came back to the court again, and I think 2 years later, sorry, I haven't got the date in front of me, and basically the pseudonym was remained in effect for another 4 years. And so there's this kind of balancing act, trying to protect his anonymity, but also make sure that he doesn't practice. So again, this is a good example of mental health condition might be relevant to extenuating circumstances, but prolonged dishonesty results in a different conclusion. One of the most famous cases involving dishonesty is the case of Justice Einfeld. So Marcus Einfeld was a former judge of the federal court, and while he was a judge, his car, silver Lexus it was captured on speed cameras 4 times over a 7-year period. Each time that happened, he claimed that somebody else was driving the car, and he forged witness signatures for the statements. So he basically forged statutory declarations. As a result of this testimony, the offences were dismissed and he didn't have to pay these fines. Well, it turned out that most of the alleged drivers weren't even in the country at the time that he claimed that he lent them his car. And some journalists found out that one of the drivers, a professor from Florida, that Justice Einfeld had claimed had driven the car, had been dead for 3 years when he made that claim. He changed his story a number of times to cover up. Ultimately, Justice Ziems found that, I'm going to call him Mr. Einfeld now because it is, Mr. Einfeld engaged in deliberate premeditated perjury to avoid incurring demerit points on his driver's licence. He concluded that Justice Einfeld had engaged in planned criminal activity in implicating others in the issue of who had actually been driving the car. He was sentenced to 3 years in full-time custody, 2 years of it non-parole, for perjury and attempting to pervert the course of justice. And then ultimately he was struck off because the behaviour involved dishonesty, and the standard that would apply, particularly to a judge, is very, very high, going back to the Allenson test and Bellingworth standard. Parker and Evans have some really good reflection points using Justice Einfeld as a case study. It's well and truly worth making sure you read that. So what about sexual misconduct? A less strict standard of sexual misconduct or conduct has been applied to lawyers than to doctors. So Del Pont noticed that fiduciary law is directed mainly to protecting economic interests as opposed to the emotional or psychological protection of the fiduciary or the beneficiary of the fiduciary relationship. So the High Court has held that sexual relationships with a client prior to the completion of matrimonial or divorce proceedings, although described as reprehensible, fall short of professional misconduct showing unfitness to practice. See Bar Association of Queensland and Lamb. However, a sexual relationship with a client could potentially be the subject of a disciplinary action, as it's conduct that's unbecoming of a legal practitioner. It involves a conflict of interest. Independent professional judgment can be affected by personal interest, and it can also be an abuse of a position of trust. So have a look at Morel, the 2004 South Australian case, in which a solicitor formed a relationship with 3 prisoners, which impacted on her advocacy. She also lied to the Department of Corrections about the purposes for visiting the prisoners, and it messed up. We talked about this one when we were talking about the duty of confidence to the client. There was a blurring of the lines between the personal relationship and the solicitor-client relationship. Now, we've mentioned mental illness a number of times along the way, and so I thought it's important for you to have a look at the Legal Practice Board and Commissioners' a policy in relation to both mental illness and fit and proper person. Both of these have been updated in recent times. So in Victoria, this policy is intended to provide guidance on the matters that need to be disclosed to the Legal Services Board and Commissioner, as well as the issues that they might consider in deciding whether a person is fit and proper to hold a practicing certificate. They're equally relevant at renewal as they are at admission. And so the QR code will take you to the policies. I think that they are well worth having a look at and having in mind as you're considering the issues here. There have been some pretty dramatic cases involving solicitors with mental illnesses. So Re B, it goes back to is a 1986 case, but the facts go back to 1982. A young solicitor who had some pretty serious mental health issues had driven past another car and shot at the occupant several times with a shotgun. And there was psychiatric evidence that had been given at the trial that established that he had a severe personality disorder and he drifted in and out of a psychotic state. He actually had formed a new religion in which he had the role of John the Baptist, and he was worried that his epilepsy meant that he couldn't live up to his grand role as John the Baptist. At the time he committed the offence, it was accepted that he was in a psychotic state, and he believed that by killing someone he could regain self-respect. It was a really, really sad story. So by the time the hearing happened, he'd been found not guilty of intent to murder on the grounds of insanity, and he was being detained in a psychiatric institute at the governor's pleasure. So Justice Brookings said that practitioners can be struck off or suspended if for any reason they're not fit to practice, but the reason may be misconduct, mental or physical unfitness, and may relate to a situation they were in. It's incongruous, he said, to hold out that you're fit to practice if you are still being viewed by the parole board as somebody who is not safe for release into the general population. But the incongruity required a suspension rather than a striking off. So again, I think this is really an interesting idea that there is a kind of compassion that's coming here. You are not fit to practice. We're not going to strike you off. We're going to suspend your practicing certificate until we can consider the application again at a later time when you are no longer at the governor's pleasure. And Another case here, actually, I'm not quite sure where I put it in this order, but Himmelhoch is worth having a look at as well. This is a case, again, involving likely mental incapacity. There was a barrister who was charged with making written demands that a client repay a debt of $6,500, but the debt was completely fictitious. The tribunal suspended the barrister's practicing certificate for 6 months, and subsequently the barrister got the practicing certificate back, but then basically did the same thing again, demanded this payment, and was again charged. The tribunal cancelled the practicing certificate and referred the matter back to the Supreme Court. Justice O'Brien said that mental incapacity might be a ground for disbarring because it can show that a person labouring under a defect of reason is not a fit and proper person to practice. While the court was concerned to protect the public and the general profession, it's a grave step to find a person is not a fit and proper person to practice. And so Justice O'Brien considered that the circumstances of the case didn't show sufficiently grave personal misconduct to warrant removal of the barrister's name from the roll. Now, a psychiatrist actually gave evidence at the second hearing that Himmelhoch had been diagnosed as seriously depressed over the 3 months prior, with sleep and appetite disturbance, marked anxiety, and disabling inertia. In its reasons for the decision, the Legal Practice Board, it's the Barristers Board, referred to a number of mitigating factors. Himmelhoch had a condition of adult attention deficit disorder that was exacerbated by anxiety and depressive disorder, and he had not responded well to psychiatric treatment. Other mitigating factors were his remorse that was shown by giving the client a written apology and the dire financial consequences following the tribunal's orders. So on referring the matter to the Supreme Court, the tribunal didn't make any recommendation about whether he should be struck off, and ultimately he was not. So I keep coming to this. These sanctions of suspension and striking off, they're same, but different. A good case to look at here would be re-S Solicitor. That's a case where a solicitor had rehabilitated himself impressively, rising to a position of seniority and trust in a company. Had he not been disbarred, it was said in evidence that he would have been appointed as company secretary. Now, actually, let me go back a step. He had been initially disbarred for some deficiencies in trust accounting, and there was an 18-year gap before he applied for admission again. Now, generally, he presented as somebody who had rehabilitated himself in this oppressive way, but actually he's basically failed to meet the duties that lawyers have, even though technically he's not a lawyer at this stage because he doesn't have a practicing certificate, but the duties that they have to the court, because he's presented the information in such a way that it could have been misleading. It was found to lack a degree of frankness, which ought to have been expected of a person who is a fit and proper to have entrusted to them as a general practitioner, or as a legal practitioner, I should say, the affairs of the members of the public. And so Justice Kay said that by framing the application in such a way to make it look like he was better than he was, and that he needed it for reasons that he didn't actually need it, that was kind of more evidence that he wasn't ready to have the admission granted. So at risk of totally oversimplifying this, if somebody's practicing certificate is suspended, then once the conditions of the suspension are complete, they're usually a period of time, but it might be something like being released from hospital, then the practicing certificate will be reinstated. But when you are struck off, you have to reapply at the end of the period, and there is absolutely no guarantee that you will ultimately get through. So that's all I really have to say about about the disciplinary process. I just want to point out sort of one thing, that it is really hard to divorce personal ethics from the institutional ethics. And as we think about all of the different elements of ethics and the way that the profession is regulated that has led us to this point, we can see some consistent patterns, and they're things that I would like you to keep in mind. Particularly, I think we need to remember this idea of being a fit and proper person to practice, both at the application stage, but also ongoing during your life in practice. And there are two sides to that: being fit, being competent, being match fit is how I think about it. Do you know what the law is? Can you follow the requirements? Can you do you have the time and the expertise to properly advise and deal with your clients? Can you manage the financial affairs and otherwise do the things to ensure that you can conduct yourself professionally? Secondly, are you a proper person for this purpose? So in other words, are you honest? Are you a person of integrity? Now, it's often, you need to have both of those things, and professional misconduct can occur even without dishonesty, and often will include dishonesty or a lack of integrity. There are serious consequences for failing to maintain the standards, but we often see when a person has strong personal integrity, even if they suffer from some other issue, including serious mental health issues, they are still likely to be, even when there is professional, or when there is unsatisfactory professional conduct, there is unlikely to be professional misconduct when a person acts with integrity and knows their own limits. So, questions, concerns, frustrations, compliments, you know where to find us. And next week we'll talk about robo-judges. I can't wait.